So, I welcome to all my dear learners for the academic counseling meeting for the subject that is MMPC 013, that is business law. In my previous academic counselings, what we have done is we have covered the two blocks, that is block number 1 and block number 2, which was majorly about the introduction to what are business laws. We have also discussed about what are the different sources of business laws. We have talked about in the last academic counseling about two of the laws, rather two of the acts, very important acts of business. We have talked about different forms of businesses. We've discussed about Partnership Act of 1932. I hope you all remember that. And then we have also discussed about the Companies Act of 2013. For today, what we do is we will be moving further to Unit 5. Basically, that is part of Block 3. Block 3 is divided into again two units. So we have in the third block General Principle of Contracts and International Contract of Sale. Let us first begin with the General Principles of Contract, that is unit number 5. Now, what are the general principle of contracts are, if I say? So what are we going to do in this? Let me quickly share the screen with you. Yeah, very good evening to all of you for your attendance. You can write down your names in the chat box and it is going to be taken, your attendance is going to be marked from there. Now, as the recording is on, I request you now to write down because then that goes as a record. So I'm just sharing my entire screen. I hope my screen is visible to everyone.
Yes, it is, ma'am.
Okay. Now, what are the general principle of contracts if we say? So in this unit, we will be talking about what is mercantile law, what are the different sources of mercantile law, what are different types of contracts, how, very important thing, what are the essentials of a valid contract, performance of the contract, doctrine of frustration or agreement to do an impossible act, appropriations of payment, and what happens if there is breach of contract. Breach means when you are not able to fulfill your legal obligation, we say that there is a breach of contract. That means non performance of the contract. Now, talking about the first, I would suggest in general introduction, as I have already informed you, that when we enter into, buying or selling of any particular good or service, we call that as a contract. So, when there is a sale of a particular, I would say goods or sale of particular movable property, then that is where we have two things. That is, one is we say that the possession changes and ownership changes. What is ownership? Ownership means first it was owned by Mr. Let's assume there are two people A and B, and the good is sold by Mr. A to Mr. B. So when it is sold from one person to the other, A becomes the one who is the seller of the good, and B becomes the person who is who's purchased that good from A, so he becomes the buyer. So in this case, possession is getting transferred from Mr. A to Mr. B. So now, previously it was owned by, rather I would say it was the possession was with Mr. A. Now the possession is transferred to Mr. B. And also in sale, what happens is ownership also changes. Why I'm talking about this, that is regarding the ownership and possession, because I will be discussing this in one of the contract types, which is called as bailment. Okay, in bailment we also say that it is a type of contract, but there only the possession changes and the sale, or the, I would say, the ownership does not changes. So there are different concepts of, primary obligation is that you should understand that what are the different laws of obligation. Now these laws under different, I would say, acts are basically where it arrives out of certain kind of rights and duties. 1 minute. So I was just discussing about that when we talk about rights and duties, any particular human being, has certain legal obligations. That is what are they bound to do. So those legal things, when you put them into related to certain particular part of a contract, that become their legal obligations. So people will never have. Let me put it in that way. Uh, if I do a promise to anyone, it is my responsibility that I have to fulfill that legal obligation. So here, if I'm not fulfilling that obligation, I'm not fulfilling my duty and responsibility arising out of that particular contract. So there are certain collateral effects of that. That is going to be, I would be, fined, or I would be asked to pay a certain amount of, like money compensation, or it might be also, if the contractors of a very serious nature, I might also be punished for the non-performance of my act. So whenever there are these promises are breached, they will be, usually initially, or what used to happen was, there was a punch system in India also, where these kind of breaches were put forward in the, for I would say, in front of the panchayats, and then those dispute between the parties were resolved. So these sources of mercantile law, when we say, I have previously also spoken about it, majority is taken from law of England. So it is basically the act of parliament or various statutes which exist from the common law of England, and certain principles of equity, from where we have taken certain basic concept about different types of contracts which are there. So if I talk about that in the Indian context, so we say that as it is called as Indian Contract Act of 1872. Previously, it was an act which was not, I would say, spread to the states of Jammu and Kashmir. But now, as you know, that Section 370, which was passed, now the law, all these laws and everything are also applicable to the entire country. So, when you talk about these contracts, there are few words, terminologies, vocabularies which I will be using from here now. A contract is basically an agreement which is enforceable in the court of law. This is the general definition of contract. When I say an agreement, that becomes basically a set of reciprocal promises between the parties of the contract. Reciprocal, that means you are supposed to do one part of your promise, and on the other hand, the other party is supposed to do his or her promise. So we say that is reciprocal promises. It is not that promise is performed only from one side. If it is from the one side, we call that as charity, not as a contract. So these set of promises comes out of certain, I would say, a few very important things, that is called as offer and acceptance. Now, these offer and acceptance, what do we mean by that? I just gave you one example between two people, that is A and B, and I said that if A wants to sell anything to Mr. B. So he is giving a proposal. He becomes the offerer. He becomes a person who is, proposing or offering a particular good to Mr. B. And if the B agrees upon that particular, proposal which is given to him or her by the offerer, that is the in terms of the offer which is given, so he becomes the offeree, or he becomes a person who's interested to get that particular thing. So any kind of an agreement, when we say, that is the result of offer and acceptance. That offer and acceptance, when it is enforced by court of law, what do we mean by enforceable by court of law? I can also come and I can give you a general offer in the academic counseling today, that let's say there is some kind of a celebration at my place, so that becomes a social offer which I am giving you. If you do not come to that particular event of mine, I cannot sue you for not coming to that particular place. But if it is somewhere where I am giving you an offer to buy or to sell anything, and you give your acceptance to it, and then that acceptance is something which is legal, where we are promising to do our own, both the parties are promising to do their part, and it is something which is, bound by legality, that means it is enforced by a court of law, so that becomes a contract. So here, when we talk about the person who makes the proposal, We call them as a promiser, we call them as a offerer, we call them as a proposer. So the offer is of two types. We call that as a specific offer or a general offer. What is specific or general offer? Like suppose if I'm giving a common offer to everyone, like I say, I want to sell a car, and I'm just giving it as a kind of a general offer to anyone who is interested to buy my car in this academic counseling meeting. So that's a general offer. I'm talking about offering public at large. But when I say that I'm giving a specific offer, let's say to Grace, so that becomes an offer which is specifically given or specifically offered to one of the academic learners, that is Grace. And for any offer, when you give, it is important it should be backed by the amount, the price of that particular product, whichever you want to buy, whichever you want to sell. So the acceptance which is given or when to the person to whom the proposal is made, when he gives his assent to, that means when he gives his acceptance to that offer or proposal, then we say that the proposal to whom, or rather the proposal is made, or the person from whom the promiser seeks the assent is called a promisee or the acceptor. Am I clear till here? Let me have a feedback
Yes,
with you,
ma'am.
and then we'll move. Okay.
Yes, ma'am.
It is very interesting, Indian Contract Act is one of the very interesting acts, because here it is where you can always link with your own self, that what I'm actually talking about. See, it is something where I mean to say is like, there are different like times, at different times, where we buy and where we sell different things. So just remember it by taking certain examples. The entire concept you can just remember it. Like if I talk about, I'm just taking two names, Akim and let's say Farida. So if Akim is a person who is offering certain, let's say, goods, and let us take that example of a good as chair. So he's offering certain number of chairs to Farida, and he is saying that, Farida, are you interested to buy those chairs from me? That becomes a specific offer, because it is regarding only chairs and it is given only to Farida. But if Akim says in the class right now that I have few chairs, anyone who's interested to buy those chairs at, let's say, 200 rupees for each chair. So that becomes a kind of a general offer which is common to all at large in the class right now and open to all. And it is now basically the one who has the money and is interested to buy will give his or her assent to, and the person becomes a promisee when he accepts that particular offer which is given to him or her by Akim. Is it clear?
Yes, ma'am.
Yes, ma'am.
Yes, it is.
Slowly the concepts of law are going to be clear to you, because initially when we started, as I said, it is altogether a very technical subject. It requires more of understanding. It's very exhaustive, too much of content is there. So that's the reason what I do is, like, wherever I feel it is going heavy, I come to discuss those things with you, so that when we do discussion, that becomes easy for you also to relate. So let me just share the screen again, so that we can again go back to what we were doing. Yeah, on the other hand, you can just write your names in the chat box. So let us continue. I was just talking about that offer, promise, proposals which are made must have certain characteristics. See, it should be intended and should be capable of creating a legal relationship. Any kind of an offer which is a social offer, or which is where you have any kind of a social obligation, that is not termed as a contract. For a contract, the intention should be to create legal relationship. The terms of it must be very certain. That means it should not be, ambiguity should not be there in giving the offer, vagueness should not be there. Like how it can be, I'll give you again another example. Again, taking the names of Akim and Farida. Suppose Akim says, I want to sell a thing which I have with me on a certain price. So now what is that thing? What is that price? He has not declared. So how will Farida be able to understand? So that is the reason we say when it is a contract, the terms of it should be very certain and should be capable of being certain. Like if here again I revise this example and I say that Akim says, I want to sell car or I want to sell chair, and price of each chair is going to be, let's say, 200 rupees. So here it becomes more certain. It becomes easy for the offeree to understand and give the assent to. It must be different from the following. That means it should not just be a quotation, it should not be just display at showrooms, and it should not be something which is in the railway timetables. That means issuing of ticket by the railway authority against the payment of to a commuter is amounting to an offer, but the timetable of the railway is not regarded as an offer. We say when the offer is when you put, when you're selling those tickets at a certain price. So that is what is called as an offer. Window dressing or window shopping also, when we say that things are displayed in the showroom, that is also which is concerned as an invitation to make an offer by the showrooms owner to the public, that yes, you can come forward and you can purchase if you're interested to buy a thing. Same manner when we go to a restaurant and we see that there is a a catalog, or there is a kind of, I would say, a menu card, or like things where we have quotations or tenders or auctions happening. These all calls are regarding invitation to make offers. So anybody who's interested can always give his or her assent to. It must be offered to an individual, or even when you are giving that to a public at large, that should be very, very specific. That is why we say that there are specific offers and there are general offers as well. It must be communicated to the offeree. The offerer is, if he is unable to communicate the things to the offeree at a reasonable time and manner, that will not be considered as a I would say, a legal offer. Why? Because you're asking a person to buy particular thing, or maybe just offering him or her to buy a particular thing. So he should also be aware about it. It should be in a very absolute manner. It should not be where you assume that you have given an offer, but the offeree is not in the know of it. So same manner how we have done offer. The another thing which is very important is from the offeree side, that is the acceptance part. Acceptance also is said to be valid when it is communicated. Suppose if you offer me a particular thing and I am ready to buy that, I need to give my communication back, or I need to give my assent to. If I'm silent and it is something where I'm not giving any kind of acceptance, whether oral or in writing, so that is not considered as a valid acceptance. The offerer may waive the communication of an acceptance. The offerer, if he feels that there is a communication which is not proper, so there the entire offer can also be waived. Acceptance must be made before the offer lapses. Like suppose we see many times on the online shoppings, what we do, that there are certain goods which are offered at a certain price after discount. You might have heard about it, right? So that is also an offer which the company is giving you, and it is a general offer. It is not only for you, not a specific person is getting that offer, but it is an offer which is given to everyone and who is interested to buy those goods. It should always be absolute in terms of the with the offer. The same goes with your acceptance also. If you do not give the acceptance in a absolute manner, then that will not amount to a legal acceptance. Moving forward, I will be discussing few things again which are very important. That is, what are the essentials of a valid contract? Very, very, very important topic from your syllabus. That is, what are the essentials of a valid contract? So when I say valid, that means, let me just explain you a few words. That is valid, void, voidable. Okay, so that you are able to connect with. Valid is when we say any contract which fulfills all the essentials which are defined by court of law. We say that the contract is a valid contract. There are 10 essentials which are listed by the court of law, and we call them as those essentials. If you fulfill those essentials, all of them, the contract is said to be valid, that is legal, that is acceptable. When I say it is void, void is the opposite of what is valid. Now, what is void if I say? The void is something where I say somewhere where you are not able to follow the legal terms and conditions which are mentioned by the court of law. Anything which violates the characteristics of a valid contract, that becomes void. Or there are certain other areas of ground also. I'll be discussing them in the coming few minutes. And the third is, children, my dear learners, is voidable. The name itself says they are avoidable. What do we mean by voidable? Voidable contracts are all those contracts which, if avoided on time, can become void. Otherwise, they are going to be considered as the valid contract. Now, you would be wondering, how is it that a valid contract, can become void if there is any kind of like avoidance done? Many times what happens is the consent when you take from the parties, those who are part of that contract, if that consent is not free, that means it is either by coercion, that is force, undue influence, that is from your position you are taking the consent. Consent means to get a kind of an approval, or it is by mistake, or it is any kind of a misrepresentation of which has happened, or it is a fraud which is done. In all these cases, if the situation lies that the consent of the party is taken where either it is through, let us say, a kind of, I would repeat again, coercion, undue influence, fraud, misrepresentation, and mistake, then if the aggrieved party, that means the party who is at loss, if he or she gives takes a legal action, then that particular contract can become void. That means it can be nullified, it can be cancelled. Otherwise, if no legal action is taken and the party agrees to all those things, even if his or her consent was not free, then the contract becomes a valid contract. Am I clear till here?
Yes.
Yes, ma'am.
Fine. So let us then just continue further, as I've already discussed about what are the different forms of contract. I'll just share my screen and I request all of you to read few points, and then we are going to discuss them. I hope all of you have these points with you. Do you have the content with you right now?
Yes,
Yes,
ma'am.
we do, ma'am.
Yeah. So if I ask you to read something from that and then we will discuss, that actually becomes easy for me, because otherwise contract, if I, or any law which I'm going to take it in that way, it would become very difficult. Just read point number 2, that is capacity to contract. I'll explain that very quickly, and you can read free consent. Read these 2 points very quickly, which is covered in essentials of a valid contract, and let us then discuss those points. Okay?
Okay, ma'am.
Fine. I give you 10 minutes for reading that thing. So all of you have read that concept, what I've just asked you to do. Can we discuss that?
Yes, ma'am.
Yeah, so what I was thinking is that I'll explain you the concept. I'll just explain you the key points, and then you can just read that, so that then that becomes a kind of an interactive academic counseling. Now when I say that there are certain things which needs to be understood in a contract, what is the first one? That is consideration. What is consideration? Consideration means that if you are part of a contract, then what is in return that the other party is getting? As in legal terms, when I say, so it is that there is a promisor and there is a promisee, there is an offerer, there is an offeree. I've just given one example, Mr. A and Mr. B. Suppose A is offering Mr. B that I want to sell a particular, let us take an example of watch, which is written in your example there also, that is on page number 115. So in return, Mr. B is paying rupees 100 to Mr. A. So that what he is giving in return is called as consideration. Am I clear?
Yes.
Okay. So that is what do we mean by consideration is. Now these considerations are usually in cash, but they can also be in kind. That means if the parties agree to that they're interested with the considerations in kind, that can also happen. So now let us understand that when we talk about these considerations, why is it important? See, if you do not have any consideration in return, if you're not getting anything in return, that becomes purely a charity. That means you are doing only from your side, but then you are not getting anything in return. So valuable consideration is considered to be that where you are also getting a benefit out of that particular obligation what you are performing. I'm using those technical words now, and I'll be using that vocabulary so that it becomes easy for you to understand. Absence of any consideration in a contract makes a contract void contract. What do we mean by void? Void means that the contract is nullified. It is not called as a legal contract. Okay, so that is what do we mean by a void contract is. See, if you can see, it is written here: absence of consideration makes the contract as void. So that is what happens if you do not offer any consideration, because as I said, it will either be considered as a gift, or it will be considered as a charity, or as a kind of a donation. So then there is not a legal obligation on one person to perform the that particular legal part or the obligation part. That is why we say the contract is said to be valid only when there is a valid consideration. Now you would be wondering, what is valid consideration? See, valid consideration means when we talk about these, payments, what you do in return, they should be legal. If you are transferring any kind of a black money, or you are transferring any kind of the money through hawala transactions, or that money which is not accepted by law, then that consideration is not going to be considered. It is important to understand that consideration should be legal. Consideration should not be anything which is not supported by court of law. Now, when we talk about capacity of parties, it means that who is competent to contract. I have already discussed about this in the last class also in partnership, where I said we have minors, if you remember. So people, those who are below 18 years of age, are said to be as minors. So the minors are not competent to contract. People, those who are insane, that is, they are not fit from their mind, they are not competent to contract. People, those who are idiots, that means they are having absent mind, and they are not in their sound of mind, then again they are not considered to be entering into a contract. A person who is drunkard, so at that particular position, when he is drunk and he is not able to think rationally what is right or what is wrong, again is not competent to contract. A person who is an insolvent, that means the one whose liabilities are more and assets are less, is again one who is not competent to contract. So these are few of the points which I have mentioned, that who is competent to contract, right? So if I talk about who is competent to contract, a person who is above 18 years of age, that is a major, is competent to contract. A person who is as of a sound mind, that means he or she is not a person who is of unsound mind. He or she is not in a state of drunk, he's not a drunkard, he or she is not insane. That means a person who is or rationally fit to understand what is right or wrong, he is competent to contract. And the last one is a person is not disqualified by any court of law. So if a person, if I say that is not disqualified by court of law, that means he should not be an insolvent, he should not be a person on any grounds where we say that his qualification. Just a second, just give me a minute, 1 minute. Okay, so I'll just share that screen again. That is what is capacity of contract, or people those who are competent to contract. Now when we talk about free consent, this is also again something which I was just talking about when related to your voidable contracts. And I was telling you, when does a contract becomes the voidable, falls into the voidable category. If any kind of a coercion, that means any kind of a threatening or any kind of pressure is given to the party to give his or her consent, then it is said to be a void contract. But then if again a person to whom those threatenings are given, he or she is not vocal about it, or he or she does not shares that particular thing, or does not take any legal action and gives his or her consent for that particular contract, it will become a valid contract. But when in a set time, if the aggrieved party takes a certain action and informs the court of law that my consent which I have given is due to any kind of a threatening, or it is a kind of a pressure which is on me, or they are threatening to detain my property, then in that case, on an I would say that contract which was about to be valid, that becomes falls into the category of avoidable, that is avoidable contract. Now there are certain categories again which is called as undue influence. Here we have a kind of that because of relationship, people take advantage of their relationship and they dominate the will of the other. Like if I say about a parent and a child, a guardian and a ward, a doctor and a patient, maybe a lawyer and a client, trustee and a beneficiary, and a spiritual master and a disciple. In all these cases, it is one is very dominant than the other. So because of the one being very dominant, they take advantage of their position and they demand for the consent from the other. Again, these contracts are voidable, that is avoidable, if the second party or the party which is not very dominant takes up a legal action and informs that the former party has taken the consent because of dominating position. The contract can be falling into the category of void, and from valid it can go back to the void category. Fraud, I think all of you understand this word. What is fraud? Fraud is basically where your intention is to deceive a party. Deceive means to cheat, right? So whenever there is any kind of active concealment of fact, this is very important line of under the law which we say, concealment means hiding of a fact, means any kind of a material proof. So when there is active concealment of a fact, by one having knowledge or belief about the facts. If I know anything and actively I am hiding that particular thing from you and still putting you a pressure to enter into that contract, that is called as a fraud. So I want to deceive you, I want to cheat you, I want to hide that particular thing. My prime concern is that I don't want that you should be aware about that particular truth. That is termed as a fraud. But here, if the silence is there, and again, a person with whom the fraud is done, he or she is not going to speak anything, that contract becomes a valid contract. So mere silence on the part of the party does not amount to fraud. What do we mean by this? That means if I am selling a particular thing which is, you know, let's say destructive, and I'm not saying anything to you that it is destructive, but you are, you have a very strong desire to buy only that particular thing, and you're willing to buy that particular thing. So that is from my side, I am not pressurizing you to buy a thing. From my side, I am silence, and that silence on the part of party from my side will not amount to fraud, will not be considered as fraud. I am not forcing, pressurizing you to buy that particular thing. Misrepresentation, on the other hand, is what? It is where you are doing a kind of a misrepresentation, but that is done in an innocent manner. So that means you are hiding a particular fact, but it is not with an intention. For you, also, that representation must be untrue. Non-disclosure is also done here to a fact, but that is something even where the party doing that non-disclosure, his intention is not to cheat. It is just to, it is a kind of a misrepresentation done. So it must be material to influence the other entering into a contract. And again, it is a non-disclosure and failure to these disclosures of a fact where a particular thing should be informed, but the person who's selling it is also not aware about it. So then in that case, it might be that those damages are hidden. So the party always gets a choice to rescind, rescind, which means to cancel the contract. Last in this is the category of mistake. Mistake basically means that it can be unilateral or bilateral mistakes. Mistakes can be of law, mistake can be of fact. So when it is a mistake of fact, we say it is subject matter mistake. That means regarding the existence, quantity, quality, nature of that particular product, we call that as mistake of fact. But whereas on we say when it is mistake of law, so when you are into a foreign country and you don't know about the law, and there is where you do a mistake, so that is called as a mistake of law. Anywhere where you reside, where you are having a citizenship, and you say that I am not aware about the law of my own country, that particular mistake is not accepted. So this is what you should know, that whenever we talk about these things, it is something where mistake is unilateral and bilateral. Unilateral and bilateral mistake means mistake from one side of the party and mistake from both the parties. So when both the parties are into a common, 1 minute, just give me 1 minute, learners. Okay, so I was just talking about mistake, and I was saying you that there can be a unilateral or a bilateral mistake. Uni means mistake from one party who's in the part of the contract, and bilateral means when it is a mistake which is done from both the parties. So if it is mistake of a fact in the mind of both the parties, then the consensus ad idem, that means they are on the same consensus. They've given their consent to particular contract, but both of them were not aware about the material fact. So that can be termed as a void contract. So this is what is called as your, as I said, voidable contract, which can be avoided in a given duration of time. and then that can be considered to be void contracts. Am I clear till here to everyone?
Yes, you are.
Okay, any questions till here? If not, then we'll move further.
No questions.
I know it is not that easy to understand law in a, just I would say a few minutes of time. It's a very, very exhaustive subject. You need to read that, you need to study that regularly, my dear learners, because from all your other subjects which are there, business law is something which is very exhaustive. The content is too much, you have too many laws to study, to understand. So it is very important that when you are coming for the academic counseling, you read the content and come to the class. How many of you are generally reading the study material? Can I have your cameras on, please, so that I can also see where are you and what are you doing? Please switch on your cameras. Come on. Good. Good to see you all. Others? Farida, switch on your camera. Very few are there in the class. I think the moment I said switch on your camera, few of them have left. They have left the meeting. Is that the case? That ma'am is going to see where are we and what are we doing? Yes, Farida. Let that be on. Let me also see you all what you people are doing. Okay, so that is what is about, some part of the contract. Now, that is somewhere you need to understand that it is that part of your syllabus. Now, you can switch off your cameras. My good academic learners, they have switched on their cameras. Those who are at least listening to me. I don't know what about others. They are not even listening to me. It's just a one-way communication which is happening. Is that the scene? So, what I was telling you is that when we talk about Indian Contract Act, it's a very, very huge, uh, contract act where we have to understand certain vocabularies. So, I've talked about few things which are the important essentials of a valid contract. I'll share a PPT also with you, content also with you. Don't worry. Apart from this, which you can refer later, and that is more easy for you also to understand the concept. Coming to the next topic is your performance of contract. Let me just share my screen again. Okay, so when I say it is performance of contract, performance is basically where we say that both the parties to a contract, they are now performing their legal obligations. I said when that performance is not done, we say it is a breach of contract. So non-performance is called as breach. Performance of contract is where the parties to a contract, they whatever they have promised, they are now fulfilling their legal obligations. So when they perform, when they do their legal obligation, it is very important for few things to be considered. One is what is the time and place of performance. So it is the duty of the promisee to make the application for the performance on a certain day at a proper time and at a proper place during usually the business hours. So what is proper time and place if we ask? So it is somewhere which is accepted to the promisor and promisee, and also during the business hours, right? So that is what is considered as to be the promise, time and place. Just a minute. Yeah, so we were talking about performance of contract, and I was telling you that when it is performance of contract, it is very important to understand that non-performance of the contract leads to breach of contract, which is called as, that the parties have failed to perform their legal obligation. I'll just share my screen so that it becomes easy for you to also read that part. And if you have that content with you, you can open that content at your end and you can read that with me. Performance of these, as I was saying, time and place plays a very very important role. And when we talk about the performance of reciprocal promises, reciprocal means that I am supposed to do my part and you are supposed to do your part. So it reciprocates, it is to be performed as per the order which is specified in the contract. So if supposingly I want to sell you a car, and I'm obviously, if I'm going to sell you a car, it is something you will be paying me back, and that is called as consideration. So, how do we go ahead with the performance of contract? Do I give you the car first? I hand over you the car first, and then you will give me the money, or it is decided in the contract that you will be paying me first certain amount of money as a booking amount, and then I'll be giving you the delivery of the car, and then the remaining amount is going to be transferred to me. So that is what is we say that how do the order of the contract is mentioned, that is reciprocal promises. When these agreements are done regarding doing an impossible act, we call that as doctrine of frustration or agreement. Now, what is this doctrine of frustration or agreement? If we say, there are times when certain kind of impossibilities are there. Like suppose if a business contractor, tells a person that I will be giving you a house which is on railway lines. So on railway lines, it is something which is not possible. That is something which is not a valid contract. It cannot happen. It is impossible to do that. So there are certain kinds of contracts, where there is impossibility. Like suppose if I say two people have entered into a contract and the one loses his life. So a person who is not there now physically, you cannot perform the contract. So it is impossible for him or her to do his or her obligation because he has already lost his life. So in these kind of situations, we say that there is impossibility, and these impossibilities are basically your certain situations which actually ends up into non-performance. So when there is a supervening event makes the performance of a contract impossible, there also we say that the doctrine of frustration applies. And where we say that the supervening event or events have frustrated the object of both the parties, and the circumstances have changed and the promise has failed to be performed, then also we say it is a doctrine of frustration. I repeat again, I said whenever two people enter into a contract, they have certain legal obligations to do and they perform their contract. But because of certain events or happenings, there might be impossibility of the performance. Death is also one reason where we say because a person is no more, he or she cannot perform his or her legal obligation. So when we say that it is doctrine of frustration, where a supervening event makes the performance of a contract impossible, that means something has happened, and because of that, the contract is not able to be performed. Or maybe where a supervening event or events have frustrated the object of both the parties, that means both the parties are into such kind of circumstances that they fail to perform their part of contract. So that is doctrine of frustration is, it's very very important. Please read that, very carefully. Many times questions in exams are also part of from this particular part. Now, when we say that there are certain contracts and we say that you need to understand that certain quasi contracts are also there. What are these quasi contracts? There is no exact definition as in of a quasi contract under Indian Contract Act, but many people like Winfield, Dr. Jenks, they have accepted the absence of a better one, and they have said, like, let us assume that there are two persons A and B, and A has delivered goods to B without any contract, either expressly or in writing, but B has consumed the goods which are delivered by A. So here now it is obligation of B to pay Mr. A, that because you have consumed those goods, so it is your responsibility also to pay him back. This kind of contract is a tacit contract. Why it is a tacit contract? Because it is implicit by the conduct, that if a person has consumed a particular good which is not which he or she does not belongs to, and it was of somebody else, so that means he is implied to now pay that certain amount back to Mr. A or B, whosoever is has offered him or her those goods. Now, if A delivers those goods to Mr. C, we have a third person coming in. We assuming him to be B and C consumed them. Then the obligation of C is to pay compensation to A. This is called as quasi or implied contract. I repeat again, I gave you an example. There are two people, A and B, and A has offered some goods to B, but and B has also consumed it. They have not entered into a contract, neither in words or in writing. But then what B has done, he has consumed those goods. So as you've consumed those goods, now it is your legal responsibility to also pay for that price. So that becomes a tacit contract. But if A has delivered the goods to C, assuming him to be B, that means he thought Mr. C is Mr. B, and C has consumed that particular goods, then in that case, it is the responsibility of the C to pay Mr. A. That becomes a implied or a quasi contract. Is it clear to everyone? Any questions, any doubts till here?
Yes, I
Yes.
have.
Okay, anyone having any concerns, you can write that in the chat box to me, and I'll go through that particular thing. Anything, wherever, whatever I'm explaining. Now, let us come to the last topic for today, that is what is breach of contract from the Indian Contract Act of 1872. Breach, as I said, non performance. So, when you are not able to perform, the aggrieved party, that means the party which is not at fault but has suffered that non-performance, what is that right which that person has? So there are certain remedies which the court of law has given to the aggrieved party. First is that which is called as common law remedy, that is for damages. That means if you have incurred any kind of a damage, then the aggrieved party can claim for those damages. Second is where we say about equitable remedy, that is certain kind of performance of contract is demanded from the person who has done the breach. So it can be in the form of rectifications, it can be in the form of cancellations, it can be in the form of injunction. That is a order from the court of law to restrain you to do a particular thing, that is called as your injunction. So now when you talk about the first one, that is for damages, various type of damages are there. We have general damages or ordinary damages, we have special damage, we have certain kind of damages which are very very, like the award, they are awarded with a view to punish the defendant, so you have those particular things also. And then if there is a breach, then you have to pay certain kind of penalties are given. Okay, that is called as your punitive damages. I'll just share my screen. I thought it is shared, just give me a second. That is what is vindictive or punitive or exemplary damages are. They're all synonyms to each other. Nominal damages, on the other hand, are said to be very, very substantial loss which has happened. But the proof of damage is necessary for claiming those nominal damages as well. And court of law has a specific, I would say, consideration for all these kind of damages, whether it is general, special, vindictive, or nominal damages. Same as I said, that if there is any kind of those losses which is equitable remedy, so that is where you go for injunction, you go for these like rectifications, you go for cancellations, you go for specific performance of contract which you demand from the person who has done the breach. That is all from your Indian Contract Act, that is unit number 13. Is it clear?
Yes, it is.
Yes, yes.
Okay. Please, my dear academic learners, I'm requesting you again and again that please go through this content. Otherwise, it is going to be very, very difficult. Some part of Indian Contract Act, when we say, we have also another law which is called as sales of goods. Now, initially, as if you remember, I said that sales of goods was also part of Indian Contract Act, but then later it was given as a separate act, and then there are certain important things which needs to be understood. So we'll just take that particular unit. The entire unit, that is unit number 16, 6, sorry, that is all about international contracts of sale. Now, what are these international contracts of sale? There are certain things which are very, very important. Let me share the screen with you again. Okay, so you might have heard about this word, that is LPG, that is liberalization, privatization, and globalization, which basically is has wiped out the boundaries among countries and made the world as a global village. So there are very substantive laws which are relating to the contracts and legal system, which actually conflict at the legal scenarios. When we talk about worldwide, so that was a need which was felt for understanding that what are going to be the international contracts of sale. Now, when you enter into certain international buying or selling of property or goods, then in that case, there are certain international contracts of sale which needs to be understood. So we have in this kind of a small historical background about it. Just a second. We have about the COVID-19 pandemic and what was the impact on the performance of the international sales of goods contract. We have about CISG, that is more about the international, sales of goods, consumer dealing with that, influence on individual national systems. We also have in this, my dear learners, something which is about the model contracts and clauses. So when you talk about the introduction part of it, so you will be reading in this that uh, when we speak about different contracts which are regarded as international contracts, they come from two different states or countries. That is why we are talking about it, that it is considered as international. So more flexible definition which is given is significant connections with more than one state or one more than one country is called as international trade. Now, this international trade is basically where you need to understand international sale of goods, which is called as CISG, that is contracts for international sales of goods, which basically limit to its scope to the commercial matters, where you exclude consumer contracts, where you you basically deal into the international buying and selling of certain goods which are part of it. Arbitration clauses are also there, which we are going to consider them later. So there is certain historical background about it, from where did it started, when was the need felt. You can just read this part. I'll just quickly move on to certain kind of laws and rules. See, there is something which is called as conventions. International sale contracts, you have laws which are applicable to contract with certain treaties. You might have heard about this word treaty. Treaty means an agreement. So the UNC has basically, has signed three treaties which are basically applicable rules which govern certain contracts. So it is first is called as the CISG, which is the Union or the United Nations Conventions on Contracts for the International Sale of Goods. Then it is a convention on the limitation period in the international sale of goods. And then we have the third one, which is the convention of the use of electronic communications in the international contracts. So all these three are the three different areas which are considered when you go for the contract at the global level. Now, there are certain national laws which are prevailing to each country. And when you go internationally, you need to understand that there is a foreign law also which needs to be considered. So, the ICC International Court of Arbitration 2013, there is a statistical report which says that frequent choice of German and French laws when you are considering different types of surveys, it is important to recall that the choice of the law for any kind of a CISG state will also include the CISG unless the convention application is clearly excluded by the parties. So here the parties have to make that thing very clear that while they are entering into the international buying and selling, or I would put it in as a commercial contracts, the party with a greater bargaining power may insist on its national laws. So this is where, when you talk about going global, this is how we decide that which country's law is going to be applicable when two countries are doing the global transactions. We have various types of treaties or principles which are followed. You can read this part. This is more about theory regarding the history. I'll just come to certain model contracts and clauses. See, there are certain model contracts and clauses such as we have a sale contract, distribution contract, international agency contract, sales representative contract, supply, manufacturing, services, strategic alliance, joint contracts, and franchisees. These are all we are talking in terms of internationally, that is going global. So it refers to legal binding agreements between the parties which are based on different countries in which they are obligated to do or not to do certain things. So international contracts are very formal, written in a proper expressed manner to make the agreements very clear, so that if there is any kind of a dispute, you have legal counsels which can actually involve, you can involve them, and in case of any kind of the disputes are there, you have arbitration clause in a contract. What is arbitration clause? That is the model of the arbitration institute of the Stockholm Chamber of Commerce, the LCIA, and the International Center for Dispute Resolution states that if there is any kind of an dispute which happens, so to protect the interest of all the parties, combining a single framework of rules with flexible provisions, allowing the parties to insert their own requirements. So you try to intervene in between through an arbitrator, and then you try to resolve those things by the clauses which are there in the Chinese European Arbitration Center, or maybe that particular international arbitration association which you are referring for in your both the countries which agree to refer to. Sales of goods by transfer of property with certainty and flexibility is something which is SOGA. As I was just informing you that it was initially part of the Contract Act, but then later what happened, that was altogether a different act which was more about certain areas regarding sales of contract. So when you say sale, it is very different from bailment. Let me explain you bailment also here. Bailment is something where we say that the goods are delivered for where the possession gets delivered. It is only the possession of the goods is getting delivered, but the ownership is not getting transferred. Whereas in sale, what happens? It is the the possession and the ownership of the contract or the act or that particular thing is getting changed. So that is the reason when we talk about certain kinds of sales of goods act, it is important to understand that how do it happens in case of internationally when you go for a contract. So certain kinds of assessments of sales of goods are done where transfer of property with certain certainty and flexibility is happening. So there is a SOGA 1893 which appears in English rule as well. French law, if we study, that is somewhere which is adopted from the French law of Code Civil, which is 1804. And there are certain other laws of transfer of property which are from German and from Australian law, where you actually talk about the abstract delivery and the later with the casual delivery. So, transfer of property basically means ownership belongs to the realm of the general formulas, while the solution of the various practical problems belong to the realm of operational rules. That is what I was just talking about, that it is basically it is a sale which is happening. So ownership is getting transferred to the other person. Okay. Now, when question emerges from the perspective of the ownership, judge must refer to the domestic law which is applicable according to the usual rule of conflict. As I was just talking about, any country which is dominant, which is more powerful, they would be having their rules applicable in that particular contract when it is entered at the global level. So that is what is all about, this particular chapter. You have certain concepts which is about influence on individual national system of CISG. You need to understand that CISG is having a very strong impact both on sales of goods, obligation laws, and also on the contractual laws related to various legal systems. It influences the individual legal system and is also felt by courts by doctrine that legal practices and lawmakers are also very largely influenced by it. Here, when I say about CISG, we say that it is influenced more by Europe by the Law of Obligation Act in 2002. So, there are some legal system reforms in the national laws which have begun or have been suggested. Like we have a New Zealand Sale of Goods Act of 1908, we have the law of Japan, we have the law of Africa also, which is called as the uh, 17 Central African countries. Those who are there with me, you can connect with your own law now, where who are currently the members of the Organization of the Harmonization of Business Law in Africa, which is also called as OHADA. So OHADA is basically intended to, or it is formed to give remedy to legal and all your judicial uncertainties which exist among signatory states, those who are into the commercial business. Right? So in this way, these are all those things which are considered while you are entering into a kind of a sale or a kind of a business which is done at the commercial level globally, not domestically. Am I clear till here to everyone?
Yes,
Yes,
ma'am.
ma'am.
Okay, hope the topics are getting clear to you and it is not that very difficult.
They are.
Need to give some more time to, go through the concept. We have our last academic counseling for the fourth module tomorrow. We are left with another two, but that is not then scheduled till now. I'll be informed about those two academic counselings, and then I hope that we have time in between so that you can also read those four blocks which I have covered with you, and then when we meet, it is going to be more productive. It is not like other subjects where I'll just talk about it and it is done. Law is more about understanding different vocabularies. Law is more about understanding various concepts. Law is more about understanding the language of those terms which are used. So the more you read them, the more you are going to be well acquainted with it, then only you will be able to understand all the concepts. So my request is that please be very active in reading the concept. Otherwise, you will not be able to get through what I am talking about. Now, moving to another thing that is the last point for your last unit, what we are talking about. I'll just move on quickly to what are the regional efforts which are made. See, there are various treaties or agreements which are signed. We have a treaty which is called as the ASEAN, which is the Association of Southeast Asian Nations, those who have approved to have trade in the goods agreement. We have treaties which are called as the CESL, which is the Common European Sales Law, which actually governs sales to both consumers and businesses. We have European members or European countries entering into various treaties and then promoting more of sales. So, as I said, we have these different agreements which are done by different countries so that they want to promote, these trade at the global level. So UNICETRAL is also one of those treaties, and the HOG have recently established certain regional centers also, where they offer significant opportunities to promote private international law instruments, including those relating to international contract law. So, in the light of the importance of this, efforts of UNICETRAL is that the Secretariat have welcomed the other nations to explore how they can promote and maintain uniformity in the interpretation of CISG. That is what we have already discussed about it. So, These are, very important areas, very important things that you should know, that when you talk about all these kind of agreements, treaties, we have a PIC, that is PICC, which basically is again somewhere we are talking about the treaties which is signed between the countries, and where they are promoting, the international or the global trade to happen. So you can just remember the names and that will become easy for you, that where which country is signing that particular treaty. Like many of these North American countries, they have a treaty which is called as NAFTA, NAFTA. That is also again North American countries which have signed trade agreements, so we call that as NAFTA. That is again, if you want, you can write them in your answers and you can add those points. COVID 19, all of us have gone through that particular phase, and it has a very strong impact on the performance of the international sales of good also, because that was a time when it was a time where all the things have come to standstill position, and it was where we have realized that it was not that easy to go for international sales of goods. So at that particular time, CISG Article 79 has provided that a party is not liable for a failure to perform any of its obligation if he proves that the failure was due to any kind of impediment beyond his control, and that he could reasonably be expected to have taken impediment into account at the time of the conclusions of the contracts, so as to be avoided or to overcome it. So here there was a reason behind it, that because of that non-performance was happening. So CISG had given the treatment also of that impediment, and which states that under a common law, four conditions must satisfy to assert that it was something where you are talking about the force majeure. So it must be beyond the party's control, like pandemic was something which was beyond your control. It was unforeseeable, that means you were not aware about it, that something the nature of this is coming. It could not be avoided, and the non-performance of the party was a result of these impediments. So these are few things, these are few points which are very, very important, and you should know about it. Under Article 2 of Uniform Commercial Code, again that is UCC of US, a seller may be excused from delay or non-delivery of the goods if performance has been made practicable by either. So that means if there is occurrence of an event and there is non-occurrence of which has a basic assumption of which the contract has made, and in good faith the compliance with the foreign or the domestic government regulation, you have given your attempt, but then there is a non-acceptance from their end, so there the delay or the non-delivery of the goods, the seller may be excused from that. Now you can just come to the summary part. That is when you talk about the many of the foreign treaties which are signed. So in business to business international transaction, it is very important to understand that when you are talking about cross border trades, the conventions, the national laws, the soft laws, and the trade usages, there are various treaties which are signed, such as CISG, PICC, UNICITRAL principles, which helps us to overcome all those obstacles which are faced by the parties in their cross-border trade through international contract of sale. So this is very important, because we cannot always have a business environment which is going to be very supportive. There are times when we have those kinds of uncertainties which are part of the business, and then the business has to abide by those things, that okay, these are things which are unavoidable. So these treaties, these legal laws are basically for bringing any harm, understanding that yes, this was something which was beyond the control of both the parties. I hope I am clear with both the units what we have covered. Any questions, any doubts still here? Yes, I'm waiting if any questions or any concerns are there from my dear learners. Do you have anything to ask?
No question.
Yeah, ma'am.
Thank you.
All good?
Yeah.
Okay, so what you need to
Yeah,
do
no
is,
question from me.
okay, what you need to do is, you need to revise, you need to go through the concept what we have done, and please meet me tomorrow when we come for the academic counseling. where we can have a discussion regarding all those topics what we have done, first module, second block, and third block. I'm repeating it again and again. It is very exhaustive syllabus of your business law. It is not that easy for me also to cover so many things in time of 1.5 or 2 hours of time, because there are so much of vocabulary language which you need to understand before we understand the basic concept of a law. So it is purely okay where if you have such kind of things that you're missing something, you're not able to understand. I've explained you the concept. When you will read those notes, it is going to be clear to you. Okay?
Okay, ma'am.
Okay, ma'am.
So if you don't have any questions to be asked from your end, can we end the class here then? So thank you so much for attending the academic counseling of today. That was on block 3, and we are going to meet in our next academic counseling, that is tomorrow.
Thank you.
Good night.
Good night.
Thank you.
Thank you so much.
Thank you.